we're moving on to the case of CargoLogicAir Limited and the impact of sanctions imposed on its Russian owner. Obviously, this is really topical, so I'm really looking forward to hearing about this. I'd just like to introduce the speakers. We have David Buchler, who is the chairman at Buchler Phillips. David is a chartered accountant and insolvency practitioner with some 40 years of experience in the field of insolvency and corporate turnaround. He was a partner at Arthur Andersen prior to becoming a founding partner of Buchler Phillips. We also have Joe Milner. Joe rejoined Buchler Phillips in April 21 after a break of 25 years, having spent her formative years with the practice during 91 to 95. She specialises in both corporate and personal insolvency and has a particular interest in the administration of insolvent credit unions. We're also here from Chris Parker, who's a partner at DLA Piper UK LLP. Chris practices in the area of restructuring with particular focus on formal insolvency processes in a global context, often in relation to the financial services sector. Chris leads the contentious restructuring group in London, working on international fraud and asset recovery, investigations, and of course litigation in relation to various financial structures. And we're also joined by Natalie Peacock, who's an associate at DLA. Natalie is a restructuring and insolvency lawyer in the restructuring insolvency team, and she's a specialist in distressed aviation matters. May I welcome you now?
Becky, thank you very much indeed. And hello to all the team here. And also introducing Becky Dacre, who is responsible for our IT. And thank goodness we're all online in the best possible way. Let me ask Joe, please, to start. And Joe, can you give us a bit of a background in relation to the company so that we can put it in the framework that we need to?
Okay, thanks, David. CargoLogicAir was an English registered company with an English holding company, CargoLogic Holdings, but ultimately it was owned by a Russian gentleman. Before we got involved, it was a highly successful company. It was the UK's only main deck freighter airline. It had two airlines, and they're sort of unique in this industry in that they front load, and they were extremely successful carrying racehorses, Formula One cars around the world. And during the pandemic, they had been particularly operative in the airlift of PPE into the UK. Before the Russian invasion of Ukraine, it had a workforce of about 110 employees in the UK and in certain European jurisdictions. Majority were based in the United Kingdom, and these were highly skilled, regulated individuals, being extremely profitable and had generated profits of about $45 million in 2020. So all in all, a very successful British company.
Thank you. And Natalie, tell me, sanctions were applied to the owner prior to any insolvency proceedings. What was the overview of that?
So actually, CLA CargoLogicAir felt the impact of sanctions even prior to its ultimate owner being specifically designated as a designated person in the UK. Following Russia's invasion of the Ukraine in February 2022, various restrictions across Europe and the UK came in, specifically that applied to airlines. These included restrictions on technical assistance being given to airlines that were ultimately owned by Russian individuals, and also airspace restrictions preventing them flying. So CargoLogicAir in the summer of 2022 found itself with two aircraft that were effectively grounded, and the airline couldn't fly, which had a material impact on the company's ability to carry out its ordinary operations.
Okay, that's good. And Chris, tell me, what did the specific sanctions mean for CLA at that time?
Sure. Well, I mean, firstly, we just need to consider this through the lens of the sanctions regime, but also it's important to remember that as a company involved in global aviation, CLA was a highly regulated business. As such, it required the necessary airline operator certificates, including in relation to regulated individuals. Natalie's going to talk a little more about that later. but this added extra layers of complexity on top of the sanctions regime. So while neither CLA nor its parents are specifically designated pursuant to UK regulations, Regulation 11.7 confirms that funds and economic resources are to be treated as owned, held or controlled by a designated person if they are owned, held or controlled by a person who is owned, held or controlled directly by a designated person, which is so basically it goes up the structure. CargoLogicAir is therefore also subject to the asset freezing provisions imposed on the parent majority shareholder. As a result, CLA's funds and economic resources, or its assets, must remain blocked, i.e. frozen, and cannot be dealt with in any way, absent prior authorisation issued by the relevant competent authority in the UK, which is the Office of Financial Sanctions Implementation, known as OFSI. So following the parent majority shareholder becoming a designated person subject to sanctions, CLA engaged its legal advisors, DLA, to assist with preparing an application to OFSI to request a license to enable the company to meet its basic needs and prior obligation to payments, which was granted by OFSI following extensive due diligence on the company. Whilst waiting for OFSI's decision on the basic needs license, CLA was prohibited from making any payments, including, but not limited to, payroll, lease payments, and payments to essential suppliers, such as IT providers. This had significant impact on CLA's ability to carry on its regulated business, as there are immediate compliance issues.
So, thank you. Natalie, prior to you guys at DLA were acting for the company. Prior to the administration of the company, were there any sort of solvent solutions that were being thought about to try and avoid administration or whatever?
Yeah, absolutely. So within the backdrop of the company's aircraft being grounded and having been notified that the parent majority shareholder was a designated person subject to sanctions, DLA worked with the company to explore as many solvent solutions as it possibly could. This included a proposal to implement an employee-owned trust structure to transfer the ownership away from the sanctioned ultimate beneficial owner to an employee-owned trust. There were two nominated individuals that this was going to be transferred to. That trust structure was proposed to OFSI as the relevant regulator and went all the way up to the senior decision makers within OFSI. Ultimately, however, OFSI determined that that trust structure would not be compliant with the sanctions and they would not authorise the transfer of that ownership.
And OFSI are part of the Treasury. They're the ultimate regulator in relation to anything to do with sanctions.
Exactly. The company were also exploring the possibility of a sale, but given OFSI's determination on the proposed employee-owned trust structure, it was felt that actually there was much more chance of getting a sale away of the business and preserving value in the business if that was done within the context of administration, having board-appointed officers run that process. So it was sort of thought there was a much better chance of preserving that value if the company went into administration and yourselves as administrators could run that process if a viable buyer was found.
Yeah. And in fact, that administration process was something which was approved by the court. It was approved by OFSI. It was approved by Uncle Tom Cobley and all. And I think that was a real thought about that. But Joe, tell me something. There's meant to be a surplus. And how will CLA meet the insolvency test if it's going to go into administration? How does that work?
Right, as we know, there's two tests for insolvency. There's the traditional can't pay the debts as they fall due, or you have the balance sheet test. Now, CLA, when we became involved with it, had about $13 million in the bank. Its pressing creditors were a lot less than that. So theoretically, it wasn't going to pass on the cash flow test. However, there had been considerable operational difficulties with regard to the company's bank account, basically from the moment it became known that there were issues with Russian-related companies such as CargoLogic. The company had kept in close contact with its bank to advise them in relation to the OFSI license, and they had a protocol in place for the operation of the OFSI license. But there were significant delays in payments being processed despite full acceptance under the basic needs license. So, for example, there had been times when payment instructions were taking well over a month to be triggered by the bank. So this was causing considerable difficulties in relation to suppliers, and more importantly, really significant problems for employees, because despite their wages being sent by the company by the bank, they weren't getting either out of the bank on a timely basis, or, as some employees were finding, their own banks were reluctant to accept payment in of monies that were coming from the sanctioned entity. So CargoLogic,
employees weren't paid.
Employees weren't paid. People who were storing the company's parts at various airports weren't being paid. The IT companies weren't being paid, which, as we all know, most IT companies, if they're not paid, will immediately switch off access to the facility. So they were facing considerable problems actually accessing their email accounts, their bank accounts, their general accounting system.
And this was even with them having an OFSI license
Absolutely.
in place for their basic needs.
Yeah. Notwithstanding the OFSI license, the banks look at every payment extremely carefully. And even payment to the same person the next month would be subject to the same strict reviews under the OFSI license. So from that point of view, we've got a solvent company, even in its statement of affairs that's been drawn up in the administration, there's an estimated surplus in excess of $4 million. So we're not dealing with a bust company here, but what we're dealing with is a company that's failing the pure cash flow test, insofar as it can't pay its debts when they fall due, not because of insolvency, but because of very much cash flow. So it's a sort of unique position that you've got a highly profitable company with $13 million in the bank, but it is insolvent insofar as it can't pay its debts when they fall due. So in those circumstances, we were facing a collapse of a company, notwithstanding what we've had in the bank.
Yeah. And in fact, when the application for administration went to court in front of Mr. Justice Michael Green, there was actually some legal precedent set at that hearing. Am I not right?
Yeah, I mean, so obviously this is a new regime. There's probably 3 or 4 leading cases on how to navigate businesses impacted by sanctions. And I think in the case of CLA, the judgment was particularly helpful around the commentary around discretion and as Joe's touched on, the cash flow test, and so it's really helpful in allowing insolvency practitioners to utilise the administration process to rescue these businesses, and we anticipate there'll be more.
Yeah, and it was at that stage that I think we took a decision to not only act as administrator, but unlike a previous case, we took that risk to act as administrators at the time of the court hearing, rather than delay the appointment until the OFSI license had come through. There wasn't an OFSI license at that time, so we sort of took that.
Yeah, which avoided having to go back for a second time once the OFSI license came through.
Yeah.
So it was a neater way of doing it.
Tell me why administration and not liquidation?
So, well, as Joe says, the company was profitable pre the sanctions. It's had a very busy COVID-19 period, transporting medical equipment for use by the British government. So when it got hit by sanctions, there was a viable business there, and consequently, our first instinct was if we could save the business, get into administration quickly, then there was a viable business to sell.
And of course, we all thought we could save the business. But Joe, what were the key considerations pre-appointment for administration?
Like any administrator contemplating appointments on a case, we had to look at various guidelines under the ethical code to confirm that we were willing to take the matter on. But dealing with a sanctioned business such as this, I think we also had to be very aware of our obligations in relation to complying at all times with the sanctions regime and the impact that would have on our discharge of our statutory duties and whether we were able to actually deal with the company's assets. As we touched on earlier, the company was in severe difficulty. It couldn't pay anyone any liabilities as they fell due. And there was a need to protect what was left of the company from any creditor taking precipitative action. Hence the decision to go for the administration order before the officey licence had been fully granted. We put all the applications in for the officey licence prior to the hearing, so that was all in motion. And at that point, we didn't know how long it was going to take to get the licence through, but we were aware that things needed to be taken under control. So therefore, we were willing to accept the appointment as administrators in order to basically keep the early engagement with officey going forward and deal with the stakeholders such as the Civil Aviation Authority and the company's employees. We were also acutely aware, because of the difficulty that the company had in dealing with its own bank accounts, that we as administrators needed to have a bank account up and running. And another administrator who I knew, who was also dealing with a Russian-based company, tipped us off very early that you need to talk to banks sort of now and not wait. So we moved into sort of very early discussions with banks in the UK, and the belief that with an officey licence in place and a court order, that we would be able to get a bank account relatively quickly. Very soon, we found that there was no appetite in the UK banking area to give bank accounts to administrators, notwithstanding court order, officey licence, etc. So we entered into very early discussions with the Insolvency Service, hoping to use the Insolvency Service account as a sort of bank of last resort. I think we always believed that we would get a bank account somewhere, that someone would do it, but we ensured that within the court order that was made for the administration, we were specifically allowed to use the Insolvency Service account from a banking perspective. But I think when we went in and decided that we were going to take the administration, I think we all believed that it was the officey licence would solve all those issues for us.
Well, it should do, shouldn't it? Because you've got the court appointment, the judge saying that the administrator is a good guy. You've got the officey licence, so the Treasury is saying we've given these people carte blanche to run the administration. You've got all of those good things going on. You can't tell me that there was a problem with the Insolvency Services account.
There was no problem with the Insolvency Service. They understood exactly what we needed. And they gave me.
So we got a good bank account?
We got given all the details of the bank account. We had it incorporated into the order. And when we were appointed, we advised the Insolvency Service, and they said, great, when you've got the OFSI license, send that to us and everything
we'll
should
give
be
you the
fine.
bank account.
Yeah, that was our understanding.
So you got the OFSI license.
Yes, we got our OFSI license. The application went in late October, I think it was, early November. Yeah. We got an indication from OFSI that they were happy in around about the new year. And then we got a draft license early January and a final license on the 6th of February, I think it was. Brilliant. Everything looked good.
And the company had its separate OFSI license at the same time, so this was for the administrators.
Yeah, there was an adjustment to the basic needs to reflect the fact that the company was going into administration. So beginning of February, we had everything.
And you got your bank account?
No.
No?
No, we didn't get our bank account, and we still haven't got our bank account even now in June.
That's not possible.
It is possible, David, you know. We presented the OFSI license to the insolvency service, who were happy for it to be run through the insolvency service account. They said we had to stay. The platform for the insolvency service account is through NatWest. So they said, we'll just send this to NatWest and get their confirmation so that we can start using the account. The papers went to NatWest, and NatWest raised a few questions about how many transactions they were looking to do and that sort of thing. So we answered those questions. But then they came back on Friday afternoon and said, really sorry, but we're not willing to deal with a Russian-linked sanctioned entity for the bank.
I think it was a really similar story from every bank that we previously spoken to. The risk appetite was really low to take it on. And I think that's specifically because the way sanctions apply, the obligation is on each individual. So each individual bank as well to make sure that they're compliant too. So,
An individual person to this criminal liability.
Yeah. So I suppose all in all,
why is it always on a Friday afternoon? It's the most remarkable situation that you've got the courts agreeing, you've got the government effectively through OFSI agreeing, you've got the insolvency services agreeing, and NatWest turns around and says, sorry guys, we're not giving you a bank account. I mean, that sounds pretty dark, doesn't it?
it does.
So a lot of pressure presumably went to try and change this.
Yes, I mean, obviously, we asked OFSI if we could bank outside the United Kingdom, given that no UK bank was willing to give us a bank account, and no, they didn't want the funds to leave the jurisdiction. So we were sort of in a difficult situation that we couldn't move the monies outside the UK, but we couldn't use the monies because we couldn't have a bank account ourselves.
And you were being threatened by Citibank, who's the original holder of these funds and bankers to CargoLogic, that they were going to close the account.
Yeah, they wanted to close the account. They wanted out. I suppose like all the other banks didn't want to hold sanctioned monies, but with nowhere to put it, they were stuck with the cash and still do have the cash under their control. But obviously, we couldn't allow this situation to continue indefinitely. We had a lot of work we needed to do, but in order to move things forward, we needed access to funds. So we tried to use as many different avenues of pressure as we could to find a bank account. We've lobbied various people with various members of Parliament and the Treasury. In particular, I'll mention Kevin Hollingworth, the insolvency minister. And we are starting to see some movement at last with regard to the use of a new insolvency services account. One of the issues is that the insolvency services account is a sort of intermingled account. It's got monies from all the estates. So they weren't happy to see sanctioned monies mixing with unsanctioned monies. Yeah. So NatWest came round to the view that they could possibly offer us a separate, non-mingled account. So we've been working with the insolvency service and NatWest to basically set up a basis for that account. There are costs involved, which we've agreed to bear, and the administrator of another company in a similar position is sharing with us. And I'm really pleased to be able to say that on Friday, we got the account numbers. We haven't got the protocol in place for the operation, but we have got some account numbers at last.
Which critically means that we can, you can start paying, so we can
absolutely
pay expenses, we can get the employees paid who've been maintained.
So no, you can't pay anything yet, because whilst we have numbers,
we don't have a protocol.
We don't have a protocol.
But we're closer.
Yes.
One step forward at a time. And celebrations that we've got a bank account. But we've got to agree the protocol and the systems for using it. But we have got agreement for a bank account.
I am conscious of time, but are there any practical legal issues which could arise from this, Chris, that the joint administrators might face?
Yes, many. I think that's a short answer to that. So it's a complex case because we're dealing with an untested sanctions regime. So every challenge we've had to overcome has tended to produce new challenges. And I think that's highlighted by the discussion we've just had about the banking arrangements. The biggest issue, I think, is time. As we said, employees haven't been paid, expenses of administration can't be paid, and therefore there's many stakeholders, the predominantly British workforce, who we haven't been able to distribute to yet. In terms of other legal issues, we can't pursue some intercompany debtors who are themselves subject to various sanction regimes. I think the big one I'm particularly interested in is we're going to most likely have a surplus. What are we going to do with that surplus? So because our shareholder is also sanctioned, it's presently unresolved. The shareholder, I think, is potentially going to be struck off by the registrar of Companies House.
Yeah, the holding company has had a strikeout application because it's inactive. We've managed to get that stopped with Companies House, but I can't imagine we'll let that position rest indefinitely. So, I think we'll be instructing you on some sort of applications to court.
Yes.
A lot of these questions.
Directions will be needed.
Yes, absolutely. No.
I'm going to ask Becky whether you want to deal with any questions, Becky, or shall we?
Yeah, we've had a couple of questions come in, actually. I'd like to put them to you if you wouldn't mind. One of the questions is, did you ask the Bank of England to bank CargoLogic?
Yes, that was our immediate thought.
Because, really?
We're under the misapprehension that the Insolvency Service Act is through the Bank of England. I think everyone has always thought that. But the banking platform is actually NatWest. We did approach one of the deputy governors of the Bank of England to see whether we could look at using the Bank of England itself as a sort of bank of last resort, as I think had been done in the early noughties for companies with environmental activists and things. Yeah. But we were advised that the Bank of England, despite being called Bank of England, it didn't have an actual banking platform.
It's no longer a bank.
So it's not a bank.
It's all contracted out, basically.
All contracted out to the various other banks who we get the same issue that they don't want to bank a Russian sanctioned company.
It's a good question because that's what it was used to us.
Yeah. You learn a lot.
Thank you. That's really interesting and surprising to know. I think I was perhaps expecting there to be more issues coming out of the sanctions regime. Are you aware of any more distress situations?
I mean, I think we're seeing a few. I remember speaking to an eminent insolvency practitioner at the time that the sanctions came in, who told me there was going to be sort of 10 years of work for our industry in dealing with the situation. I think that hasn't come through, but I think we're seeing more. I think it's helpful that the ones that have gone through, so VTB and well, I can never pronounce. There's decent guidance and good experience that have been built up through those cases, but I can't believe there are more, and I would expect to see some.
I think we are aware of others because the banking issue has come up with an R3 group, so there are others out there, and there's certainly other companies that are looking for advice. Whilst probably not directly sanctioned, those that have had dealings with Russian investors or similar are facing issues as sanctions continue to be imposed on connected parties with Russia.
But it's a good point, because there has actually been really good coordination, within the restructuring insolvency community to try and find solutions to this. So for me, with the help of R3, it's been a good example of how we can pull our minds together to try and solve issues.
It sounds like a further example of where we are working despite legislation and struggling. Another example is dealing with sort of employment law at the beginning of appointments, and it seems like these two things should mesh, and yet they don't.
Yeah. Yes, I would agree on that. And I think there's a lot of developments that could take place sort of going forward as we explore further. I mean, as Chris said, we don't know what to do with the ultimate surplus. It could sit in a bank account forever, but I suppose until there's a political decision as to what will happen with such funds, we'll be left, but we will look to make a directions application to try and get that aspect resolved.
I think it's also clear that under no circumstances will the administrators distribute a distribution without the OFSI and the courts sort of agreeing what the process should be and who should be receiving and who shouldn't be receiving.
Yeah, I mean, it might be worth picking up on the fact that there are two different types of OFSI licenses at play here. You've got your basic needs license, which the company already had pre-administration, but you need an additional license, which is an administrator's OFSI license at the point of Joe and David being appointed. So that took about, I think, 6-8 weeks to.
It did, and it's worth saying it's a very detailed license. It required us to basically anticipate every step we might want to take in order to get permission to deal with employees, pay people, even listing payment to agents or advertisers, bond, insurance, everything was listed in that license so that we could actually run the administration. So it's quite a detailed lot of work to be done up front and anticipate exactly what issues are going to arise in the administration. Banking being the least of them.
Yeah. I mean, it was interesting, Becky, that one of the things that we had problems with is that our IT people had not been paid. So they needed to be paid before they would release any of the IT and give us the books and records and the details and everything else, which was online. Of course, we didn't have any money to pay them. So at this moment in time, we're still waiting for release of funds in order that we can generate what we need to generate.
For example,
from the IT.
There's very specialist stock because of the aviation.
Oh, we seem to have lost them.
Sorry.
Team, your camera has gone off.
Can you hear us?
Can you hear us? Yes, we can hear you. Oh, you're back.
Sorry, IT. This isn't the CargoLogic IT issue. But
that was the sanctioned individual pulling the plug.
Yeah, and as I was saying, we need access to the IT in order to be able to sell the stock, because with aircraft stock, there's detailed records held on a bespoke system that we need to have access to. So once we get our protocol in place for running the bank account, we'll be dealing with getting that information so that that we can take things forward in relation to the stock.
We've had another question from the audience. Were the banks able to give you any explanation as to why the OFSI license wasn't sufficient comfort for them?
No, it's the short answer to that. We're just told that we're not minded.
I took it very personally.
Yeah,
I think the answer is that the OFSI license is in favour of the company, not the banks, and therefore the banks have their own potential criminal liability to work. And you know, if I suppose if you operate as a bank, well, why would you want to take on that liability? And that's the struggle everybody's having who's dealing with the administration of sanctioned entities.
I think.
Sorry, let me just say this. We were very lucky because at the end of the day, it all turned on being a political decision to try and generate some help. We were quite lucky because one of my friends and a consultant to the practice is Mark Field. Mark was the MP for Westminster, so he did know the routes through Westminster. And that has been very helpful in unlocking some things and putting some pressure on in the right way. So, sorry, Natalie.
Oh, no, that's okay. I was just going to speak a bit about the way that the licenses work as well. So we obviously have OFSI, and they conducted quite substantial financial due diligence on all of the creditor payments before granting the company's basic needs license, and have done so when that's been extended as well. They did the same when we proposed the administration license to them and went through. I think Buchler Phillips, as proposed administrators, you both prepared a business plan with all the eventualities of how to meet the purpose of administration. And even in the licenses themselves, the specific bank accounts are named. So the insolvency service account, as you said before, Joe, that specific account is named. So we thought that would be enough comfort, and that obviously are giving sort of, their seal of approval on this is okay from our end. But obviously the banks do want to feel comfortable themselves that they've gone through that process as well.
That's been really interesting. We've just got a couple of minutes left, so I wonder if I could ask you, given the complexity of what you've talked through this morning, if you just have some key takeaways for the audience.
Yeah, you absolutely need good legal advice. You need your lawyers with you the whole time, because there is a real journey here. And I have to say, with thanks to DLA, because DLA at the moment and ourselves, as you can imagine, haven't been paid. The employees, the creditors haven't been paid. So everybody's working and has worked in the past a little bit on this, on spec. And, we're hopeful this will unwind, but at the moment it hasn't.
I would actually say that and thank you very much. But it's actually having a really good sanctions team is very helpful.
Yeah.
It's just Nat and I representing DLA here, but we have a large sanctions team who've done all the work with OFSI. But I think my biggest takeaway is actually it's just the amount of time that everything takes. We went into this thinking that we could probably get a bank account up and running within 2 or 3 months. But as I said at the beginning, every time you get through one challenge, another one pops up. But I think hopefully Joe and David have kind of blazed a trail that'll make it easier for others finding themselves in this situation.
Yeah, we hope that we don't come back here next year to give you the same story of hesitation. Resolved within the next few months at least.
Well, thank you all. That's been a really fascinating insight into dealing with the collapse of the company under the sanctions regime, and I think an excellent example of the restructuring profession trying to pull together and find solutions where they're not immediately obvious. Thank you.